morning, everyone. I'd like to welcome you to our webinar on strategic housing developments. My name is Deirdre Nagle and I lead the planning and environment practice in MHC. I hope that you find the webinar interesting. We're going to run a couple of polls, the questions for which should be appearing on the screen. There's two questions. We'll give you an opportunity to respond to those now. The first one is, what are the main obstacles to the success of the SHD planning process? And the second one is just to get your views on what changes you would like to see in the SHD planning procedure. I'll now introduce the speakers. Stephanie Lodola and Grainne Tiernan are associates in our planning and environment team, and they each will discuss some SHD cases and talk about some of the reasons why these consents are being quashed in the courts. James Benson is the Director of Housing Planning and Development Services in the Construction Industry Federation. He'll discuss why we've seen such a low correlation between the number of planning permissions granted through the SHD process and the low numbers that are actually commencing on site. Suzanne Murray is a barrister who has been involved in many cases involving SHD developments. She'll speak about the overarching flaws in the current procedure, trends in the case law to date, and the potential changes that may be made to the legislation. With that, I'll now hand you over to our first speaker, Stephanie Lodola.
Good morning, everyone. Thank you for joining us. I'm going to give you a quick overview of strategic housing development in the first instance. So I know most of you are aware of this, but Sinead, if we can go to the next slide, I'll bring you through a quick background in strategic housing development. So strategic housing development, the system was introduced by the Planning and Development Housing and Residential Tenancies Act 2016. So the reason why this system was introduced was a bid to fast track the planning application processes for large scale residential developments. So to qualify for this process, you have to be a development of 100 or more houses or student housing that contains 200 or more bed spaces. The reason why this is a fast track process is that SHD applications are made directly to An Bord Pleanála. So this bypasses the traditional planning route where the application is made to the local planning authority. The process requires applications to be decided within a mandatory 16-week time period, again, trying to shorten the process and move these developments along. However, there's been a worrying trend. A number of judicial review proceedings were taken against SHDs and have been successful. So we're going to look at a couple of cases that look at the pitfalls that these developments kind of fell into and what to avoid in your own permission application. So if we go to the next slide. This is what to look out for when making an SHD application for permission. So when you're submitting your application, these are top tips to kind of remember. So recent case law has seen SHD permissions quashed for a variety of reasons, and these have included the inadequacy of surveys that were submitted with the application for permission, the inadequacy of the plans that were submitted with the application for permission, failure to state reasons for contravening the development plan, and failure to adhere to the objectives of the development scheme. So if we look at the next slide, we're going to look at Balscaden. So this is the first case I'm going to look at that deals with an example of an SHD permission, and it was quashed due to the inadequacy of the drawings accompanying the permission application. So this was an unusual development. It's on a hotel for 177 dwellings and associated works, and involved an excavation of an Ice Age esker and the removal of a significant amount of soil, sand and gravel. And this is quite an environmentally sensitive site. It's an extraordinary number of European sites. There's 9 designated SACs under the Habitats Directive and 10 SPAs under the Birds Directive. So a very environmentally sensitive site. So the proposed development was granted permission through the SHD procedure, but the court quashed the permission and for the development on the grounds that the board reviewed irrelevant considerations by having regard to the previous grant that was subsequently quashed and the inadequacy of drawings provided to the board. So the first point is actually quite specific to the case at hand, but the second point is of a broader application, the inadequacy of drawings point. So if we look at the next slide, the inadequacy drawings point is in relation to the regulations, the planning development regulations. There's specific requirements that the permission for application must be accompanied by plans and particulars necessary to describe the works. And there's a couple of different regulations that outline exactly what kind of plans need to be submitted with the application permission. So in this case, there was no planning drawings for the sheet piling structures, which consisted of 5 huge structures up to 50 meters high. However, the only drawings that were submitted with the application for permission were sketches with incomplete dimensions, and they were for proof of concept purposes rather than construction drawings. Here, the court found that the lack of formal drawings showing the dimensions and locations of the sheet pilings was contrary to these regulations and rendered the grant of permission devoid of meaning. So permission is usually granted on the basis of the plans and particulars submitted as part of the application. And if these plans and particulars don't have sufficient information to build out the development, this condition cannot be complied with. So the permission was quashed on this basis. And on the next slide, I'll look at some kind of top tips to remember. Where first I'll actually look at the Trailford case. This is a permission granted to Trailford Limited, and it was quashed on the basis of inter alia inadequate surveys. So in this matter, the proposed development was for a development of 509 houses and 152 apartments with associated facilities in Drogheda. Well, here the court found that the board had inadequate information on the effects of the avifauna arising from the proposed development, and to exclude the potential for significant effects at the screening stage for an appropriate assessment. So in this case, the board didn't have adequate information before it to rule out whether certain birds would use areas affected by the development for alternative high tide routes. So here there was no surveys undertaken at high tide. So when birds were displaced by high tide, there was not sufficient surveys to indicate where the birds might go and if they'll be going into an area affected by the development. So there was nothing looking at if the areas would be going to for high tide routes, or maybe for a foraging resource or for overflight purposes. And these birds are a protected species under the Boyne Estuary Special Area of Conservation and other Natura 2000 sites. So the reason why the court quashed the decision on this basis is that they said there's an obvious lacuna in the information before the board in relation to bird surveys. So this means that the board couldn't have made an accurate decision on whether an appropriate assessment was required without the additional surveys that should have been conducted at high tide. So the screening exercise did not comply with the requirements of the Planning and Development Act, and the permission was quashed on this basis. So for these two cases, the top tips to remember when submitting an application for permission is to look at the plans and particulars submitted with the application for permission for the SHD development. These must include adequate detail to comply with the regulations. Then the second point is in relation to the surveys, as was undertaken with the Trailford case. So adequate surveys must be undertaken and submitted to the board to ensure that the board has sufficient information before it to make an adequate decision. Now I'm going to pass you over to my colleague Grainne, who's going to bring you through the next couple of tips. Thank you. Grainne, you're just on mute there if you want to unmute yourself.
Oh, sorry. Good morning, everyone. I am just going to talk about some case law that has come up in the context of development plans and developments and planning schemes. So when you're submitting your planning application in general, your planning application has to adhere to the planning policies that are set out in a development plan. So the development plan is set every 6 years by the local authority. But under the SHD legislation, you are allowed to go outside the development plan in certain circumstances. So if you adhere to a certain criteria, you can go outside the development plan. So this is the criteria that I've listed below. So if it's of strategic, of national importance, if there is conflicting objectives in the development plan, or if the development adheres to a wider government policy, and government policy is often issued under Section 28 government guidelines. And also if the patterns of development and permissions granted since the making of the development plan. Next slide. So this has come up quite a lot in the last few years in respect of building heights. So in Ireland, traditionally, building heights in cities and towns have been about between 6 and 8 stories. So this has been an issue in the last number of years, particularly in cities where there's been huge population growth. So the government has seen the need for taller buildings. So they made a significant intervention in 2018 when they issued the Section 28 guidelines called the Urban Development and Building Height Guidelines for Planning Authorities. So the basis of these guidelines was basically that planning permission should not be refused on the basis of building height if the application is otherwise in accordance with planning. So developers were basically given a nod to start building higher as opposed to just outwards, and that's what started happening. So you started having planning applications being sent in for quite high buildings. But this was controversial because it's not what people were generally used to, seeing in their area. So this is one of the reasons why they've kind of come up before the courts. And there's been quite a few cases, but I'm just going to discuss one of them. Next slide, please. So this is one case where it occurred, O'Neill versus Lodola. So this is a case that occurred in 2020. So this was a development for 245 apartments ranging in height from 6 to 10 stories in Finglas. And it exceeded the maximum height of 16 metres that was permitted under the Dublin City Development Plan. Now, this building wanted to go up to about 32 metres in some parts. So it was quite significantly higher than what was permitted under the development plan. Next slide, please. So when this came before the courts, they just kind of discussed, the provisions of the SHD legislation. And, the court was very clear that the SHD legislation does allow you to go outside the development plan in certain circumstances if you adhere to the set criteria. But the board has to specifically state the main reasons why they're allowed to go outside it. And also the materials before the court didn't disclose that the 2018 building height guidelines applied to the development and that they had applied the set criteria of the 2018 guidelines. So because they failed to state the reasons for going outside the development plan, then the permission was quashed on this basis. Next slide, please. So the courts have also distinguished between what is a development plan and what is a planning scheme. So a planning scheme is quite different to a development plan. Planning schemes they provide quite a detailed planning framework, whereas development plans tend to be, a bit more vague and quite general. And planning schemes are designed in areas known as strategic development zones. So they are areas that are known for being of strategic or national importance. Next slide. So just to give you an example of where some of these strategic development zones are, so there's quite a few in Dublin. So you have Grange Gorman, Grand Canal Dock, Poolbeg West, Clonbarris and Adamstown, just to name a few of them. Next slide. So this was discussed in the courts and it came up in Dublin City Council versus An Bord Pleanála. So this was a decision by Judge Humphreys that was delivered in November 2020. So what happened here was that a planning permission was granted by the board in Grand Canal Dock, but the building heights exceeded that was provided in the planning scheme. So Grand Canal Dock planning scheme permits 10 to 12 stories, and this development was higher than that. But the developer here tried to argue the point that because the SHD legislation allows you to go outside the development plan, this should also apply to planning schemes. But the court disagreed with this. So next slide, please. So the court said that planning schemes are actually quite different to development plans, and on that basis, the same provision that doesn't apply to the SHD legislation. So the court basically said that planning schemes provide a very detailed planning framework. And because of that, it has primacy over the development plan, and the boards are required to work within planning schemes and they can't go outside of them. Also, planning schemes cannot be diluted by being mentioned or incorporated into a development plan. So on that basis, the planning permission was quashed. But this case is under appeal, and it is due to be heard by the Court of Appeal at the end of July. So it's definitely one to look out for. Next slide. So this is just some tips just to remember if you're planning to submit an SHD application, or if you're being judicially reviewed or you think your development is going to be judicially reviewed, is just to make sure that you state the relevant provisions of the SHD legislation if your development is planning to go outside the development plan, and also state the reasons why you think that it should be allowed to go outside the development plan. Also the same thing for the building height guidelines. If you are planning to invoke them, state specifically in your planning application that you are planning to invoke them and the reasons why you think that your development should adhere to the criteria set in the guidelines. It's up for the board to state the main reasons, but you can help the board along by doing this, just providing the necessary evidence that they need. As the law currently stands, the SHD legislation does not allow a material contravention of a planning scheme. So if you are submitting an SHD application in a strategic development zone, just make sure that the objectives and the height limits of the planning scheme are followed. But again, this is under appeal, so just one to look out for in July. And so now I'm going to hand you over to James.
Thanks very much, Grainne. I suppose the introduction of the shared equity scheme, the introduction of the strategic housing development legislation in 2017 has proven effective in securing planning permissions for residential schemes. And this is clear from the figures produced by the board themselves. The overall mechanism itself has led to many improvements between the applicant, the local authorities and the board inspector interaction. For example, the prospective applicant and design section 24/7 pre-application meetings between the local authority provide much enhanced disciplinary interaction at those meetings, where we see now the respective representatives from the different local authority departments such as roads, drainage and landscape and also attending. And this is key for early identification of requirements that will be seen through the application process. However, there are clear areas where enhancements could be seen in the scheme or in a similar scheme in the future. Judicial review process is a key area within this, and Stephanie and Grainne have spoken about this in detail, and we'll hear more from Suzanne shortly. Some of the other considerations revolve around the 16 weeks period. Is that too short of an assessment period, given the scope of detail and volume of files that we now see connected to applications of this nature? Requests for further information is another area which is continually referenced. The jury is still undecided in this aspect. However, some would argue that many SHD applications that were refused could have been considered for grant had on board Penala the mechanism to request additional information from the applicant, and then avoiding the unnecessary delay and additional expense of needing to reapply. So while we've already heard this morning about some of the technical reasons why permissions are increasingly being overturned, I'd like to speak briefly about the practical challenges and viability from the construction perspective. As I said, we know from the board's own figures, some 40,000 residential units have been granted up to late November 2020 of last year. Breaking this figure down, we saw in the region of 29,000 apartments and 11,000 homes were granted approval. However, it should be noted that the measure of success cannot be viewed solely through the lens of securing planning permissions. We need to look at the higher level of permissions translating into actual starts and ultimately homes delivered. And to achieve this, we need to see an economic development and viability testing introduced into not just the SHD system, but into wider planning. And if we address this viability, it has the potential to be a game changer, not only in the SHD legislation, but as I say, in wider planning. So moving on to my first slide. The premise of the SHD scheme's introduction was to help assist and recognise the challenges of our housing crisis and try and promote greater delivery of homes in a more efficient and practical manner. To provide some context to our current situation, it's widely agreed that Ireland needs somewhere in the region of 33 to 35,000 new homes across all their tenure types annually, and we need to see this for the next 2 decades. So that's across private, social and rental. To achieve this, we're going to need to see certainty and speed in the delivery of viable housing schemes, while still respecting the importance of the planning process. The number of homes that won't be delivered this year depends on what point in time you start from. If we take 2 years ago, expected delivery for 2021 would have been in the region of 28,000 homes. Last year, after the initial restrictions from COVID, projections for this year were revised downwards to 24,000 homes. Unfortunately, we now know that this year we can expect to see delivery only in the region of 16,000 homes. So depending on our starting point, we're going to lose between 8,000 to 12,000 homes this year alone. Taking that against the overall demand of 33,000 homes as a minimum, will fall less than halfway short of the 16,000 homes that we will deliver this year. And looking back to a time period of when the SHD scheme was first introduced, going back 5 years, we've seen under provision of almost 80,000 homes in that period alone. So additionally, what we do know from 2020 is that after easing of restrictions, we again saw a low level of commencements for up to 5 consecutive months as the focus moved on to completions. And then this was also mirrored with a high level of apartment completions in the back end of 2020, due to the fact that apartments generally tend to be only completed at one point in time during the year, and you don't see the natural traditional phasing that you would see associated with housing. So these are some of the difficulties. This is the context of where we currently lie on delivery, and it's some of the factors that will impact on delivery and numbers, which will extend not just through to 2021, but we will see that impact and shortfall translate into 2022 and 2023. So moving on to my next slide. I suppose with planning reform, there is positively a number of targeted measures that could bring greater certainty and speed to improve our planning system and indeed the SHD legislation in Ireland. And this could go a long way to help our common goal of much needed new homes. The current scheme, which is due to expire in February 2022, and that's a result of the extension from the previous restrictions of the pandemic last year, does provide an opportunity to enhance a similar planning model. Some of the areas that could be looked at within that perhaps would be the inclusion of a validation list of documents that might be required for large-scale residential applications, and this would assist in providing strong proposals at the outset. Another similar suggestion might be to prepare an A3 booklet which covers the headline details, which reference the specific details that will be contained within the overall application. This booklet could deal with adherence to planning guidelines, for example, looking at density requirements and show how the application has been prepared in coming to terms with calculating that density requirement. The same exercise could be done for housing mix, main traffic routes, etc. The whole idea would be that the summary document would allow for the various planners and inspectors to read the more salient and pertinent points and then dig into the specifics as we continue through the main application process. So moving on to my next slide. I suppose the key message today is of viability and potential for planning reform. I suppose currently our plan and permission process does not guarantee viability. There is a disconnect between the planning and economic development. And if we are to achieve viability, development management must account for economic development during our application and granting of permissions. If we look at SHD commencements at a very high level, only about 30% of commencements have started to date. An examination of these permissions that have been granted but not yet commenced would indicate that non-viability as the primary reason for delayed commencement. This non-viability needs to be assessed in the context of constraints of the unnecessary complex and onerous planning process, which we have and which is causing delays within our process, which is adding to costs. The costly conditions attached to granted permissions that we see more so now, more than ever, requires the private sector to deliver infrastructure, not just for the granted scheme, but also to cater for the upgrades in the locality, where the onus is now on the home builder to upgrade the deficits in roads and water and wastewater infrastructure, which we now see as a result of years of underinvestment. These are key elements restricting supply, and it is this non-viability of developments that has led to a low level of non-commencements. It also needs to be noted that the time correlation between granted planning permission and commencement on site is a lengthy process. By the time the necessary compliances and compliance obligations have been confirmed with the board or planning authority, it will take time to put those obligations in place. It will take time to get the funding arrangements in place. So it's very difficult to see any commencement on site as a minimum, but from somewhere in the region of 12 to 18 months from time of grant of planning permission. So in some respects, we're still in the infancy of the SHD legislation, albeit that we're coming to the end of its current term. There's also a misconception at the moment of land hoarding, and that this is the reason for low level of commencements. I suppose from a home builder's perspective, we seek to secure planning permissions and build homes in the most efficient manner, and any delay is counter to this. It should be acknowledged as well that legislation also exists to prevent land hoarding as it stands with the vacant site level. And we see this where it's been in place now for a number of years, and it's up to a 7% levy on the market value of the land is paid in tax, where the registered owner cannot demonstrate why zone lands which are capable of delivering residential units in an area where there is demand do not do so within a specified period. And we've seen this rolled out through many parts of the country at the moment. A key consideration and a recommendation that we would put forward for whatever scheme we do see in the future for inclusion in all planning and not just in the future SHD or what might take over in February 2022 would be viability testing. At a very early point and potentially pre-planning stage at pre-planning meetings, the outline objectives and conditions should be discussed with the various planning departments and divisions. This would provide a more visible understanding of what costs are likely to go with the development and allow a more educated assessment on costs at that earlier stage. And you would argue that it's hugely inefficient use of resources both on the applicants and those assessing, on the planning authority and on Bord Pleanála side to go through a full planning process only to find that a project isn't unviable after granted permission and then ultimately never starts. And it's fully appreciated that any economic assessment shouldn't be the ultimate reason for grant or refusal, but it is an area that needs to be brought into the conversation and needs to be brought into that conversation at a very early stage. We've seen that almost 3/4 of approved planning permissions were apartment units. And again, it's widely agreed and recognised by independent consultants that apartment viability is a problem in Ireland. It's only viable in a number of limited postcodes in Ireland, and in most cases through the insistence of an investment fund. And those funds play a very important role in being able to ensure that those rental accommodations or private homes are delivered. Our planning guidelines in particular and our density requirements mean and dictate that use of higher level of apartments as we try to achieve compact urban growth. However, applying a density requirement on a national basis with a one-size-fits-all measure that doesn't take into account regional dynamics will delay projects, or at worst will mean that some projects will just never be built. So some of the wider potential for reform in both the SHD and our planning process would be, as I said, the examination for potential greater use of outline planning permission to help define the strategic design and planning at the outset rather than at the end. And this will help reduce costs. As I've mentioned, the introduction of viability testing on all plans would ensure that we have an equitable way into market requirements, and we will see a greater translation and correlation between the number of planning permissions granted and those units that actually commence and start on the ground. And this should be done as part of a wider and more thorough root and branch review of our entire planning system. And as we know, this was committed to in 2017 as part of the earlier programme for government. And finally, I suppose ensuring planning guidelines are fit for purpose, not just in generality, but importantly in 2021, to ensure that design standards are streamlined to reduce cost and maximise available space for development. We've seen a very significant change to the needs and demands of the public in the last 12 months, and this does need to be taken account of in what the market preferences are likely to be over the next number of months and years. So just to click on to my last slide, again, my thanks to Mason, Hayes and Curran for the invitation to speak this morning and for organising the event. And I'll now hand over to Suzanne.
So good morning, everybody. First of all, I'd like to thank Mason, Hayes and Curran for asking me to speak here this morning. And I'm going to look at 3 issues. They're trends, flaws and potential changes in the SHD regime. If I could have the next slide, please. So while the legislation has been in force since 2017, we're seeing now a number of trends coming through in the cases that have been taken before the High Court in terms of grounds that are raised in judicial review. And quite unusually for legislation that has been in place since 2017, one of the areas that is now been looked at is the whole definition of strategic housing development and what actually is strategic housing development. And there have been a number of judgments that have dealt with the issue of other uses. And as you'll know, in a strategic housing development, they can include other uses which are subject to a quantum level and also ones which are facilitated under the zoning relative to the actual application site. In the case of Morrison and Bord Pleanála, we looked at whether or not those other uses had to be solely confined to the people who are going to be occupying the residential development or whether they could be accessible to the wider community. And the court held that they could be accessible to the wider community. Then in Dublin cycling campaign, the issue of whether other uses which are extant on the site also had to be included in the calculation of the quantum of other uses, or whether it was solely the other uses proposed as part of the planning application. In that particular instance, the court held in calculating the quantum of other uses, you had to look at the other uses that were existing on the site and which were going to be retained on the site. Now, that particular judgment has been granted a certificate for leave to appeal. No hearing date has been set for that yet, but presumably and hopefully it'll be before the end of this particular year. Could I have the next slide, please? Aligned to the whole definition of SHD development is the zoning of land. And as you'll know, that in order for it to be classified as a strategic housing development, the land has to be zoned residential or for residential and other uses. These issues as to what actually that means are now becoming grounds for challenge. They were considered in the case of Highlands Residents Association and on Board Penola, where in that particular case, while the land was zoned residential, it was subject to a special objective in the development plan, which meant that it actually wouldn't be available for development until I think in or around about 2021. And in that particular instance, the court held, well, it wasn't actually available for residential development, and as such, the development in that particular case was a material contravention of the zoning of land, and the board were therefore precluded from granting it. Another issue which is arising is whether the board's construction of zoning for residential use is correct. As you'll be aware, the board take it that if land is zoned residential, and if residential is either permitted in principle or even open for consideration, then the land is zoned residential and a strategic housing development can be accommodated or on that particular land. The issue of whether or not an open for consideration use is sufficient for the purposes of having a development deemed to be an SHD is something which is arising in the cases of Clonres and Conway versus on Board Penola. They're joint cases which have been heard and which we're awaiting judgment in at the moment in time. Next slide, please. Another issue which is which has been raised in a number of cases, and which I think is going to be raised in more cases, is this issue of the prospective applicant, and in particular where the prospective applicant differs from the applicant for planning permission. So as you'll be aware, in order to, prior to making the application, the prospective applicant has to enter into consultations with On Board Penola. They then get a decision from the board as to whether or not the documents formed a reasonable basis for an application, and then they can go on and make the application for SHD directly to the board. But there is an issue as to whether the prospective applicant has to be the same as the applicant for planning permission. And there are a number of cases where the prospective applicant actually differs to the applicant for planning permission. While those cases in the context of SHD haven't been heard yet, a case was heard in the context of the strategic infrastructure development provisions under the Act, which contains a similar requirement for a prospective applicant and then an applicant for permission. And in that particular case, which is Chase and On Board Penola, which relates to the Indover incinerator down in Cork, the court held that the prospective applicant had to be the same as the applicant for permission. And I do think that this is potentially a ground which we will see arising more because of the judgment in Chase, where the facts of the case so admit. Could I have the next slide, please? Grainne touched upon the material contravention of the development plan and the building height guidelines and referred to the case of O'Neill and On Board Penola. But other trends are arising in relation to these building height guidelines. And for those of you who are familiar with them, you'll know that SPP or 3A provides that the board can grant permission for heights which exceed the development plan, provided specific criteria are met, and those criteria are set out in section 3.2. But at the end of section 3.2, there's a section on other assessments. And there is a question arising, well, do those other assessments arise in every particular case? Or if they don't arise, do you have to set out in the application why they don't arise and why you're not submitting, say, for example, a bird flight risk collision, or whether you're not, or why you're not submitting an assessment in relation to the impact of the building on mobile phone signals. So you need to look at the last section of section 3.2, which deals with other assessments. And they also include, say, for example, the daylight and sunlight assessment, and that featured in the Higgins and On Board Penola case. And the daylight sunlight assessments are ones which are featuring more in judicial review, particularly in relation to whether or not the BER standards are actually being correctly applied in the assessments and in the daylight sunlight reports that have been submitted with the applications. Could I have the next slide, please? Obviously, in all of these cases, there are going to be multiple grounds relating to environmental impact assessment if one is required, and appropriate assessment or screening for appropriate assessment. One ground which we are seeing coming up more and more is a screening for environmental impact assessment. And as you'll be aware, there is a difference now between it's almost the EIAR is almost now a 3-stage process. There's a preliminary examination, a screening determination, and if necessary, an EIA. And the question that arises is where the board carry out a screening determination, is there a requirement that a separate statement be before the board which deals with the other relevant assessments which have been carried out other than those under the EIA directive? So that would include, say, for example, assessments which might have been carried out under for flood risk, maybe assessments carried out under the Water Framework Directive, appropriate assessments, strategic environmental assessments of various plans and projects. They would all come under this relevant assessments. This is a ground that we're seeing working its way through the court. No judgment has been delivered on that, but we would expect to be getting a judgment in a case called Waltham Abbey and in Bord Pleanála in the near future in relation to that particular issue. Just the next slide, please. So everybody has ideas and everybody has views in relation to SHD and whether the SHD legislation is working or not. These are just a number of flaws which I think people need to consider. The first is as Stephanie stated earlier on, the applications have to be decided within 16 weeks. But in reality, the assessment is carried out in an 8-week period because you have 5 weeks to make a submission, and then 3 weeks after that for the chief executive's report from the relevant local authority to be submitted. That in effect leaves an 8-week period for the board and the inspector to carry out their assessment. And there has to be a real issue as to whether that's a sufficient amount of time in order to carry out a robust assessment, particularly in the context of applications which are now for maybe 500-600 units. So that's the first potential flaw, or certainly I would consider that to be a flaw in the SHD process. The next one, which is a matter of some debate, is whether or not the process would benefit from further information and the board being allowed to seek further information. I think the jury is very much out on this, certainly in the context of submissions that are made, where submissions are made which raise particular issues, say lacuna in certain documentation or query the assessments that have been carried out. Certainly in those cases, a further information round might assist. But the problem with further information is that it drags out the whole process. And if the whole idea is to have quick decisions, then that's not compatible with a further information request. The third issue is a greater clarity is required in relation to zoning and what land zoned residential or for residential and other uses actually mean. As I said, we are waiting for a judgment in the Clonres and the Conway cases, so that will hopefully deal with this issue. But certainly there is confusion out there as to when exactly land is zoned residential. Does it have to be residential in the title? Is it permitted in principle? Is it open for consideration? And I think once we have greater clarity on that, then that will do away with a number of the grounds that are coming through. Then finally, again, a number of grounds and a number of challenges are based on material contravention of the development plan. The board have the power to grant a material contravention of the development plan, provided it doesn't relate to the zoning of land. We're seeing the board relying more and more on ministerial guidelines to give them the jurisdiction to grant material contraventions of the plan. However, in doing so, you can see that there are problems in the reasoning that the board are giving and contained in the board order. And there is maybe either a requirement to tighten up that, either to remove the power from the board to grant material contravention in the development plan, or to actually make it much clearer when those actually, when they can actually utilise that particular power. And my final slide, please. So as you're all aware, the SHD legislation is coming to a close. It's supposed to be closing on 31st of December this year, although there is some talk that the deadline has actually been extended till February 2022 because of COVID. I haven't actually, while I understand that that was an answer to a parliamentary question given by TD in the Dáil, I haven't actually seen any legislation or anything to the effect which is saying it's going on to February 22. So we'll just have to await that. But it's certainly clear that the legislation, as we currently know, can't be extended any further. It has to come to an end, and also the programme for government has expressly stated that they will not be extending the particular legislation. So then there are really two options. We have a whole new act, and I understand that this is a possible option that's been considered, is a kind of a super enhanced Section 34 application, which is, as you know, Section 34 is a normal application route, and whether or not then there'll be a hive off there for large-scale residential developments. It's possible that it could apply to developments in excess of 100 units, as opposed to, that there might be an increase in the cap. Current cap is 100 units and maybe increasing to maybe 200 units. It might also be the case that it will be limited to particular geographical areas, and you won't be able to avail of it on a nationwide basis. They were certainly recommendations that were in the John Martin report, which was prepared at the first stage when the minister decided to extend the life of the legislation at the first instance. I suppose there are questions as to what the new procedure will be if it is this enhanced Section 34. Will it just be to the board? Will it provide for a planning authority stage as well? Will there be a further information request if it is just to the board? Will it allow for the material contravention of the development plan? I think that's proving quite a controversial one, particularly in circumstances where there is no planning authority stage. And I think that is a matter that may be looked at. And as I think both James mentioned, use it or lose it. I mean, certainly the whole idea behind the SHD legislation was to get decisions out quicker, but also to actually get the houses built. And while certainly the anecdotal evidence is that while the board are making their decisions within the 16-week period, there is a question as to whether or not it's actually resulting in houses being constructed. And certainly the Martin report did suggest this idea of use it or lose it, but ultimately said, look, it's too early in the process to consider that at this stage, but it might be something which the department may keep under review. And certainly it is an option that the department might consider including in any new legislation which comes out in allowing for enhanced applications in the context of large-scale residential developments. That's all from me, and I'm going to hand you back now to Deirdre Nagle.
Thanks very much, everyone. I think that was really interesting, and a lot of detail actually was gone into, and I can see there's quite a lot of questions already being raised. I don't know if we've gotten the results of the poll yet. Oh, you have. It's flashing on my screen. So just to share those results with you first. The first question was, what are the main obstacles to the success of the SHD planning process? And the majority of people, 55%, said that it was the number of JOR decisions resulting in the planning permissions being quashed. Secondly, and interestingly, given its fast-track nature, 27% felt that delays in the planning process was the main obstacle. And only 19% felt there was insufficient guidance on how to properly navigate the SHD planning process, which is very interesting. In respect to the second question, what changes would you like to see in the SHD planning procedure? Only 11% felt additional time to allow An Bord Pleanála to make a considered planning decision. 38% said additional resources provided to allow An Bord Pleanála to make a considered planning decision, which I personally think is absolutely required when such a heavy burden is being put on the board to make decisions so quickly. But the majority of people said both of these changes would be welcome. Just turning now to the questions, we have a lot of questions in, so I'll really do my best to get through as many of them as possible. I think, James, there's one. I might just start with you. There was a question in about, could you give a more specific example of what economic viability assessment would include?
Thanks, Deirdre. I suppose just in respect of that, again, this isn't something that we would suggest would be the ultimate decision making, whether someone would be granted or refused permission with respect to the overall planning process. But again, viability is so key, and it's one of the significant factors as to why we're not seeing a high level of numbers translating from those that are granted permission and starting on site. You know, we're still only in the region of 30% of those applications granted. if we don't have viability, we just won't see the units started. That's why I believe it's key that we see viability assessment at a very early stage. What I mean by that is that we can go some way to start a discussion to try and identify what the true costs of delivery will be for a project. That's the full development costs. It's very easy to say what the bricks and mortar element will be for any home, apartment, but it's the wider aspects, the soft costs and the overall additional elements that go in, the conditions that will be imposed at the end of planning permission. We need to get an idea of that at a very early stage, so the full maths can be done to see if a project is viable. And as I mentioned, if it's a waste of resources and time and money on all sides, both applicants and those assessing, if we don't have that at an early stage. A good example of that is density requirements, being able to know how many units will be required in that particular area, and getting clarity on that at the outset. This is a huge area that causes ample discussions and challenges during the SHD process and wider planning. But I think water and wastewater infrastructure is another area within that needs to be referenced. At the moment, we have a situation where we have the establishment of Irish Water in 2014. Unfortunately, now when we go through the planning process, while there's acknowledgement and involvement, we still don't know at grant of planning permission stage if, in fact, you have secured water supply to that particular development. If we don't know at grant of planning permission what the actual cost of the infrastructure upgrade will be, and unfortunately that is the case, that it's only at the latter stages of your connection application process with Irish Water will you know if there's a cost and requirement to go along with an infrastructure upgrade. And we're seeing that increasingly so for wastewater these days. That can add 15 to 20,000 in some cases per unit. And that's enough to throw a unit from being viable to unviable very quickly when taking into account the affordability gap that we see at the moment. So they're just some of the areas within the early viability assessment. It's really to get that discussion at an early stage to make things as efficient and as practical as possible from the outset. And I think someone referenced it earlier on. Like, it's the certainty that provides, it is so important for everyone.
Thanks a million, James. We have a question in on roughly how many SHD applications are being submitted in Ireland and what percentage of them are successful. Grainne, is that something?
Yeah, so there was a report done by on board Planola back in November 2020. And just off the top of my head, just from memory, I think there was, at that point anyway, it's probably more since then, but there was about 180 applications that have been granted. And I think about 230 or 240 had been submitted. So the majority of them are being granted. So that's just a rough idea of numbers.
Thanks a million. I just maybe Suzanne, there's a question here, or anyone indeed on the panel. Just have the department confirmed what an applicant must do to avail of SHD by the cutoff date in February 2022. Informally, they basically have heard that a stage 2 submission will suffice, but how long do you have basically to lodge a full application thereafter? I don't know if anyone has heard anecdotally and anything around the cutoff point.
Deirdre, I haven't heard anything in relation to the cutoff point. I mean, the Act does provide that I think once you've entered into pre-app discussions, then you're allowed to continue through the process once the legislation comes to an end. There is a provision in the Act. I'm just trying to find it at the moment in time, but I'll find that and I can come back to it if there's another question for me.
That's great. There was a... So James, just one about, this person is interested to know if we're seeing shift in SHD with the introduction of the National Planning Framework, and are there cases which exemplify planning and development alignment or not with recent legislative updates in the area?
Yeah, it's a very interesting question. It's a great question, really, because I suppose we now see a situation where we have the national planning framework, and within that there's a number of objectives, obviously, for what would be considered more sustainable and proper planning going forward. We have an implementation framework that falls out of the national planning framework, and that looks at a number of key areas. It looks at prioritisation of lands. It looks at transitional arrangements where a certain number of milestones will be hit by 2026 and 2031, and it also tries to seek a greater pattern of development, more sustainable development, and promote infill and brownfield sites. So more use of I suppose, schemes and developments with access to services. I suppose the implementation of that framework is very laudable, and it should be seen as a facilitative tool to promote development and zoning of lands, something that we would be aware of at the moment, and most attendees would be as well, that there's a number of authorities going through upgraded development plans at the moment. They will need to take into account the national plan framework, the implementation process, migration figures, all those elements, population targets that have been given to them as part of that wider policy. And therein lies a number of difficulties, because to reach those targets within the national plan and framework and the implementation framework within one development plan just won't be possible. We need to see full utilisation of the transitional arrangements. So not just in the next development plan in a particular area that all the objectives will be just thrown into one. We need to see them spread out, because if we don't, we won't see the facilitative tool that it's designed to be. It'll actually turn into be very restrictive. We could see underzoning and under provision of lands, which will obviously for both, not just residential, but for wider infrastructure. And if we don't have that availability for infrastructure and residential zoning, we're going to have huge issues down the line. So we are seeing a shift. I believe we're seeing a shift, and I believe we need to see that proper implementation of the plan and framework, and importantly, using those transitional arrangements where local authorities will not just do it in one development plan, they will do it over a series of the next 1 or 2 development plans. And in that way, we can promote more sustainable development.
Thanks a million, James. Just another question. Stephanie, just why are the courts allowed to substantially review the board's decision in these cases? It's noted that you referenced the courts looking at the adequacy of surveys.
Sure. So that's a good question, because the courts can't usually come in and substitute their own decision for the board's decision. Like, they're the competent authority with the experience behind it to make the adequate decision. So it's not in every circumstance the courts can come in and just, quash the decision. So if there's an administrative body exercising like their discretionary decision-making functions, they can only be set aside if it's kind of classified as unreasonable. And that's a specific legal term. It's like, it has to be in relation to the Wednesbury principles of unreasonableness. But this can include taking into consideration certain things they shouldn't have taken into consideration for, or if there's anything they looked at that they shouldn't have looked at. So the courts usually aren't in a position to interfere with the board's decision unless there's an obvious deficiency in the material, or when I was talking about Trailford, it said there was an obvious lacuna in the surveys that were provided. So if the best scientific knowledge requirement has not been observed, the courts then kind of step in to quash the decision. So this is when I was talking about the surveys in the Trailford case. There was nothing in the environmental impact assessment report or the NIS or the inspector's report that suggests that the surveys took place at high tide. We kind of discussed how important it was that surveys were undertaken at high tide, because to look at the displacement of the birds and to see if then the environmental impact on the development of these displaced birds at high tide. So it's a key requirement that adequate surveys and stuff are provided to the board. And without this information, if the board then made a decision where there's an obvious deficiency in the information before it, and at that point the court then can then come in and say, look, I'm not substituting my own decision for yours, or I just think there should be the factors should be weighed differently, but you didn't have the information before you to make a reasonable decision. So the court can then come in and step in and quash the decision on this basis. And I think that's important. I see there's another question about how can the propensity for objectors seeking judicial reviews be reduced? And I think this is an important related point, because you have to apply for leave to judicially review a decision. And if all of the improper information was provided to the board, if the board's making a decision based on all the important factors, then it's harder for the court to see there's an arguable case, and it's harder for the court to then come in and quash the decision. So I don't know, Suzanne, if you have anything further to add on that.
I think just in relation to challenges and judicial review, obviously the right to participate in decision making is enshrined in the Aarhus Convention. We also see it in the EIA directive. But even going back before that, since 1963, we've always had a right to participate in the planning process through making submissions. And there's always been a right of judicial review in respect of the decision maker's ultimate decision. So I don't see how the right of access to the courts is going to be curtailed. And certainly, I think if there is any attempt to do so, I think it's going to be quite strenuously opposed, and we'll see a number of challenges in relation to that. I mean, for example, even in the context of SHD, while none of them have ever actually been heard, there have been a number of cases which have actually challenged the constitutionality of the 2016 legislation on the basis that it removes one element of the planning process, i.e. the planning authority stage, and people are saying that this is unconstitutional, the procedures applied by the board are unconstitutional, they're not fair, they're not in accordance with natural and constitutional justice. So any further erosion, say in particular in relation to access to the courts, would, I imagine, be strenuously opposed, and I'd say you'll find a whole new area of litigation just arising out of that. I just see a question here for me in relation to someone's asking what the name of the current case on zoning is. There are two cases which are dealing with the issue of when is land zoned residential. They're called Conway and Onboard Planola and Clonres and Onboard Planola. We're waiting from judgment from Mr. Justice Humphreys in relation to those cases. I would hope maybe we'll get that in the next, well, certainly this legal term, so before the end of July, but it's Clonres and Conway are the two cases there.
No, that's really great, Suzanne. I do think sometimes about the restriction of people being object to the process. Any attempts to change the legislation or standard requirements in that regard just can give rise to a whole further raft of cases and jurisprudence on the issue, which ultimately might just be counterproductive. I think I'll just do one final question, and James. Just what are the panel's thoughts on project splitting by developers, whereby they split development projects to reduce the number of units per the development in order to avoid the SHD process?
It's another interesting question, I suppose. In one vein, developers or home builders are accused of going down the SHD route to try and avoid some of the potentials for objections, and it's probably worth noting, similar to Suzanne's point earlier on there, there is if we take this back to the very start, at development stage, when zoning of lands are undertaken, that's a point in time as well when people have an opportunity to make observations, so they have that in addition to the options available to them under the SHD. In respect of the project splitting, I think we need to take account of what's realistic and what's practical around our country, not just in urban settings or suburban settings. In regional Ireland, it's the strategic housing development for 100 units plus. In regional Ireland, a project of 20, 30, 40 or 50 units will be strategic, and you don't really see it. Like your normal developments will be, only in the scheme of 30 to 40 units, to seeing what the market is like and if the project or development is actually fundable in that area. So you don't tend to see large scale projects in regional Ireland of 100 plus, and that is often one of the reasons why people go down the traditional route, and you don't see a greater number. It's really utilised more in the urban settings.
Thanks very much, James. I think we've just hit noon, so I just want to thank everyone very, very much for tuning in, and I really want to thank the speakers, Suzanne, James, Grainne and Stephanie. I had a very easy and pleasant job this morning. And in fact, the participants were chairing the meeting themselves, so that was also helpful. But look, thanks very much, everyone, and I hope you have a great rest of your day. Bye-bye.